The Minister of Economic Development and Competition Commission have expressed concerns that the current provisions of the Competition Act don't adequately allow the competition authorities to address issues created by the large number of highly concentrated markets in South Africa. The Minister has just published the Competition Amendment Bill. Now, for more on this, Rosalind Lake from Norton Rose Fulbright joins me. Thanks so much for your time. What's the most important aspect of this draft bill?
Well, I must say it's a wholesale redraft in terms of making sure that everything the Commission wanted fixed in the Act has been fixed. But really what we're seeing throughout is a theme of giving the competition authorities more power to be able to help small businesses and previously disadvantaged firms from competing.
How will they do this, especially perhaps with a focus on small businesses?
So what they've done is throughout the Act, wherever they deal with either abuse of dominance, so by big firms, or merger provisions, exemptions, what they've done is they've said you have to consider the impact on small businesses and previously disadvantaged owned firms. There are also very extensive changes to the market inquiry provisions which enable the Commission to look at particular markets and issues that are making it difficult for those small businesses to compete. The
draft bill takes also quite a different look at mergers and ownership. Can you talk us through a little bit more of this?
So this is where the competition authorities have been going for a while, but this is really just putting it into the bill. What they want to do is have the ability to look at all the cross-directorships and cross-shareholdings that companies have, to see whether that has any impact on competition or affecting a particular market. So when you'd normally look at if you own another company, now they're going to look at if you have a small shareholding, does that impact competition between you and that company that you are potentially acquiring?
So if we don't look at the level of small businesses and this draft, if we look at it as consumers on a day-to-day basis, how will this draft bill affect us, if in any way?
So that's, it's complicated because competition is supposed to protect consumers because it brings pricing down significantly. I'm not sure that this act is going to achieve better competition because it's very focused on the public interest, perhaps not looking necessarily at competition, but hopefully we'll see more competitors in a number of markets, and that is always better for consumers.
Okay. The draft bill also proposes that, and I'm quoting, the restrictions on dominant firms not to engage in anti-competitive price discrimination in relation to its customers be expanded to apply to suppliers of dominant firms too.
Yes.
What does that mean?
So what this means is dominant firms have always been prohibited from discriminating between their pricing to their customers in a way that stops them from competing. They've now said, okay, we need to look after the suppliers to a big firm because maybe they have too much bargaining power, and that either that company will have to supply at a very, very low price that they can't afford or something like that. So they've really said it's not only when the dominant big firm is supplying, but also when they're a customer that they can cause problems to competition in a market.
People have often said that our legislation is very good, but the enacting of that legislation perhaps leaves a lot to be desired. What will be different, if anything, with this draft bill?
I think that's certainly true of many, many other acts in South Africa, not true of the Competition Act. The Competition Commission is a very effective regulator. We don't always agree with one another on different sides of the fence, but they are actually very good at it. And competition law is certainly the one that has been vigorously enforced, and the authorities will continue to do so. This will just make it easier for them to prosecute people for anti-competitive conduct.
Thanks so much for your time. Rosalind Lake from Norton Rose Fulbright joining us in studio there.